but welcome to Johnson Law Group's Lunch and Learn webinar with attorney Taylor Goldschmidt. Taylor, so happy you're here with us. Thank you for making time for us.
Thank you for having me, of course.
Yes. If everybody doesn't know Taylor is a family law attorney here in our Colorado office. She's going to walk us through one of the most important topics for any Colorado parent going through separation or divorce, parenting time, right? Custody, which child custody is now known as parenting time here in Colorado. Specifically, Taylor's going to touch on how to build a plan that actually holds up and protects your kids, okay? And so if at any time you have questions for Attorney Taylor, feel free to use the chat. She will address them as the presentation goes on. And without any further delay, Taylor, I'm going to turn it over to you. If you could share just a little bit about yourself and how you got into family law.
Sure. So hi, everyone. Again, my name is Taylor. I am an attorney here in Colorado. I also practiced in California, which is where I began my practice originally. Was there for about 5 years, and now I practice here in Colorado. I practice almost exclusively family law, with dipping my toe in a few other things here and there, but family law is more my passion. I really enjoy working with our clients directly, assisting people, with real life problems rather than working with big corporations. So that's one of the main reasons that I became a family law attorney, and I've really enjoyed my time here at Johnson Law Group.
We're so happy you're here, Taylor. Thank you.
Thank you. So if we could go to the next slide, Stephanie. All right, so this slide, we've got a couple of numbers going on, and before I get into kind of the substance of the presentation, I want to just take a minute on why this topic deserves the attention and the time that we're spending on it. So 4 numbers here. The first number, 85%. This is the majority of Colorado parents who create a parenting plan during their case never formally modify it, okay? So that means whatever plan you put into place today could be what governs your child's life for 10, 12, 15, maybe even longer years, depending on how young your child is when you put the plan into place. So this just kind of goes to show that the decisions that you make in your initial current parenting plan can have very long-lasting consequences, and that we need to be considering how those consequences may play out in the future as your child grows older. Number 10, second number there, that's the 10 best interest factors, which are the legal backbone of every parenting time determination in Colorado, okay? So a judge isn't necessarily just free to do whatever they think is best, right? We have statutes and precedent of what they are required to determine. And those 10 factors, those 10 best interest factors, are specific statutory factors that the judges have to consider in these sorts of disputes, okay? So we're going to walk through some of those most important factors today. The number 3 there just represents the average amount of time before families typically come back to court to address their parenting plan. Almost always the reasons they come back is not necessarily some dramatic change or conflict. Often it is because the original plan was vague, ambiguous, and that leads to conflict or tensions between the parties. These parenting plans, when they are vague, they don't anticipate enough situations for the future, and often parties can't agree on what that means. That also plays out in situations too where maybe there is a vague term and one party is kind of using that in their favor with regards to the parenting plan, which, we want to try to avoid that circumstance. And then the last point here that I want everyone to take away from today is the number one conflict driver is in parenting cases is this vague language of the original plan, right? So language, for example, like as agreed, or with reasonable notice, or when possible. You know, in the context, when you're drafting the plan, it may sound like you're being cooperative when you're writing it, that you're going to equally kind of co-parent and co-communicate. Years later, perhaps your relationship with your co-parent has changed. Perhaps the circumstances have changed, your child has grown older, and these sorts of vague terms are going to become a constant source of dispute. So again, we want to kind of try to avoid that language when we're drafting parenting plans, especially in the initial parenting plan. All right, Steph, I think I'm ready for the next slide. Okay, so just to basically go over in general what we're going to cover today. 4 separate topics. So topic 1, as I mentioned from first slide, is Colorado's legal framework of how we or courts determine parenting plans. Okay, so I want everyone to be able to take away what's the legal standard that Colorado applies. And that's the best interest standard. So, and it involves those 10 specific factors that we're going to go over, the most important ones for you to consider. Topic 2 is going to be discussing building a strong parenting plan. So what does that actually contain? There are essentially 5 big components that should be included in a parenting plan. And in many cases, we see that parents are missing, 2 to 3 of those big components in their plan. So we'll go through those components that should be in place. The third topic is going to be examples of the most common kind of models of a parenting plan. And what I mean by that is, how does a schedule actually work on your calendar? Is it a week on, week off schedule? Is it a 2-2-3 rotation? Are there hybrid schedules? There's a lot of creative ways that you can obtain a schedule of actual parenting time that works best for both parties. So we'll kind of go over those options and the situations that maybe best fit each of those scheduling options. And then finally, we will talk about common mistakes to avoid. So both in how the plans are written themselves, and also how parents behave during and after the case. So some of these mistakes are very common, but have very serious real-life consequences. So I want to make sure everyone kind of takes that away from today. And then we'll close with a Q&A. So if you have questions, put them in the chat, and we should have a couple of minutes at the end of the presentation to go over those questions. All right, so let's go to the next slide and start with the legal framework. Okay, so topic 1, again, Colorado's legal framework. Parenting time and the best interest standard. So before you can build a parenting plan, you need to understand the legal framework a Colorado court operates within, right? So the foundational principle here, every single parenting time decision in Colorado is made through one lens, and that is the best interest of the child. It is not what's fair to you. It's not what you think is reasonable. It's not what you want. It's the best interest of the child, okay? That phrase comes directly from our statutes here in Colorado. It's called the Colorado Revised Statutes, and the specific section that has these factors that we consider is Colorado Revised Statute 14-10-124. So that statute is going to list these 10 specific factors that the courts must weigh. Again, this isn't optional. This isn't subjective. The judges are required to apply these factors. And most typically in orders, you will even see that the court addresses each and every one and makes findings related to each and every one. So understanding these factors, of course, is very important for many different reasons. And the primary 2 are really that first, if you're negotiating a plan with your other parent, you should know what the judge is going to consider, right? Because that tells you potential arguments that you may have, the potential facts that may weigh in your favor or against you, and really helps you kind of assess what you're going to need to show the court, right? So second, if the case does go to court, the judge, again, is literally going to go down this checklist. So you want to be in as good of a position on as many of these factors as possible, and knowing that beforehand so that you can ensure that you are considering these factors and behaving in a way that is positively reflecting these factors is going to go a long way in terms of being before the court on parenting disputes. Okay, I think we are good to go for the next slide. Which should be, oh, Steph, I'm sorry, did you have the best interest standard already pulled up?
Yes.
Okay, sorry, I'm still on that slide then.
Okay,
So yeah, and again, this slide is going to kind of give you, as you can see on the right, the 10 best interest factors summarized. And then some of these kind of legal concepts that we want to go over. So on the left, the first thing to note, and I think Stephanie mentioned this, is that Colorado doesn't actually use the term custody. We've replaced the old vocabulary, so you're not going to find custody or visitation in any Colorado family law statutes, and you're typically not going to see that in any orders or parenting plan. Many states still do use those terms. California specifically uses those terms. So when we're talking about like physical custody, what you would normally think of as physical custody, in Colorado, the term that we use is parenting time. And then legal custody, what you would typically think of as legal custody, is going to be referred to here as decision-making responsibility. So we'll talk about the difference between those tonight or today. And the point is that, you know, these aren't just word choices. The Colorado legislature was really trying to reflect a kind of philosophical shift away from an idea of custody and litigation and one parent winning and one parent losing, and more towards how do we share parenting time and how do we share decision-making responsibilities, right? The second kind of key concept for today that I want everyone to kind of take away from, because this is a big common misconception, there is not an automatic 50-50 joint parenting time presumption in Colorado. Okay, some states do still have this. Some states are moving towards a presumption. Colorado has not, which really just means we don't have statutes and legislation that is specifically telling the court you have to start with a presumption of 50-50. Now, often in an initial case, do courts try to kind of take the mind frame of children should share equal time with their parents as much as possible? Yes. And then obviously there are factors that can influence or change that decision. Plans are really individualized, right? So what's right for your family and your children is going to be different than what's right for somebody else's family. So these cases are very fact intensive, and you know, a couple of different facts can change the outcome of what a parenting plan is eventually ordered to be. The third kind of key concept here is that both parents do retain parental rights regardless of the schedule. So even if a parent has less parenting time, it doesn't mean that you've lost your rights as a parent, right? You still have those parental rights, even if you have quote unquote less time than the other parent does. And then again, on the right, we have those 10 best interest factors. So let's just kind of hit some of the ones that come up most commonly in contested cases. So that first one there, the relationship between each parent and child. This is, I would say, one of the most important factors. Which parent has been the primary caregiver? Which parent has typically handled the school pickups, the doctor's appointments, the bedtime, day-to-day routines, right? And again, this is a good example of it just depends on the case, and it always fluctuates. I mean, we have cases where it can be very, very clear that one party has been the primary parent. And we have cases where it can be pretty clear that both parents have really jointly shared these responsibilities, right? So the facts of each case are going to be very different, but this is certainly a factor that the court is going to heavily consider. The next really big important factor is the ability to encourage the other parent's relationship with the child. And this is a factor that maybe some people don't love or surprises people, but indeed the courts are actively watching for parents and how they treat each other. And specifically if a parent is behaving in a way where they are perhaps undermining the other parent's relationship with the child, not supporting it, maybe even going so far as to try to manipulate the child, things like that are very serious in these cases, and it can seriously negatively impact your case if the court does have evidence and reason to believe that you are engaging in behavior that is undermining the other parent's relationship with the child, right? So in the ideal situation, the court wants to see that the parents are, despite maybe their differences and despite maybe their conflict, able to keep the child out of that, right? So that's a really important thing to keep in mind is you may not love your co-parent, but they're your co-parent, and you need to act in your child's best interest by not influencing and letting that relationship with them impact the relationship that the child has with the parent. The third big factor here is the ability to encourage, the history of domestic violence or child abuse. So of course, these two facts are going to weigh heavily in any sort of parenting case. Obviously, if there is a history of domestic violence between the parties, the court is going to want information on that. If there is any child abuse that has happened, the court is going to want information on that. That might include things like police reports. That might include things like Department of Human Services involvement. Things of that nature are going to be facts that the court considers, okay? And they can also kind of trigger specific statutory protections as well. And so that can create some complexity in the cases as well. And then fourth, we have the child's wishes, if they are sufficiently mature to express those wishes. So this is another common question I receive. Many people have a misconception that children of the age of, I believe 13 is the number I keep hearing, that if the child is 13, that they can just choose what they want. Not the case. I will say that the child's preferences can definitely carry weight, and the older they are, the more weight that may carry with the court. So for example, if you have a 14-year-old who is expressing, concerns or a specific preference about the parenting plan, the court is typically going to weigh that heavier than the court would if it was, say, a 7-year-old, right? And again, there's no real magic number. I always kind of approach the situation of course, what the child's concerns or emotions are important. Typically, I find that the court is going to be more prone to really weighing the child's thoughts at around the age of 12 or 13 and above, but it doesn't mean that it's not relevant if the child's younger than that. But again, the court's never going to let the child decide what they want, right? So these are, these factors, just keep in mind these factors as we're talking about building your plan, because everything that we discuss is ultimately about optimizing your position with these 10 kind of dimensions in the forefront of our mind. Okay, ready for the next slide. Okay, so topic number 2, building the strong parenting plan. Now that we've kind of gone over the basic framework, let's build a plan. A parenting plan, as you probably know, is a legal document. Once it gets filed with the court makes it a court order, and it is enforceable as a court order. It's going to govern your child's lives for potentially years, right? So again, depending on how old your child is when the plan is put into place. Sometimes children aren't even 1 year old. And sometimes they're later in life, but regardless, these plans are going to be in place typically for many years. I have seen a very wide variety of plans. I've seen plans that are literally 1 to 2 pages long, maybe handwritten, very vague. You know, they leave a lot of information out, and that can cause years of subsequent litigation, right? So we want to avoid that. We don't want you coming back to court and spending a ton of money to relitigate a parenting plan that could have specified these terms in the beginning. And again, on the flip side of that coin, I've seen plans that are very detailed, 15 pages long. And those are typically harder to dispute, right? They're more detailed. They encompass many more situations, right? So being specific and trying to account for further situations is important in that parenting plan. Being specific, it's you know, it's kindness to your future self and your children. It's not that you're trying to be difficult, it's that you're trying to come up with a plan that's going to work for everybody. And it's not just going to work now, it's going to work 5, 10, 15 years from now, right? So I consider typically 5 components that every strong Colorado parenting plan must have. So we're going to go through those components right now, and that would be on the next slide. Okay. So component 1 is your regular parenting schedule, right? So this is your day-to-day, your week-to-week routine. What days does the child go with which parent? What time are exchanges going to happen? Where are the exchanges going to happen? This needs to be very specific. Named days, named times, named locations for the exchanges. Do not write as mutually agreed. The language, again, it sounds cooperative, but it requires both parents to keep agreeing indefinitely. Very often it does not work. The second component is the holiday and the vacation allocation. You need to name all of the holidays, right? Not just Christmas and Thanksgiving. Think about other holidays like Mother's Day or Father's Day, right? We typically have each Mother's Day, mother gets to have the child. Each Father's Day, father gets to have the child. Even the child's birthday is something that you may want to include in the parenting plan. Spring breaks, fall breaks, winter breaks, summer vacation, right? We want to include all of these holidays. Who has the child and when? Is it going to be an alternating schedule, year to year? This section, you can get really creative, right? And, you know, I've seen a very wide variety of holiday plans. Some parents have come to agreement where, you know, dad wants the child every Christmas and mom wants the child every Christmas Eve, and that's what works for them. But regardless, it needs to be put into the formal court orders. You may think you have an agreement with the parent now. In 5 years, that might not be the case, right? And so this holiday and kind of vacation allocation portions of the parenting plan is where a lot of litigation comes in because it's maybe not as complete or specific as it needs to be. The third component, communication and exchange terms. How are you going to communicate about your child and on what platform? So, for example, there are very common apps that divorced parents or parents who are co-parenting children will use to communicate. The 2 most common that we typically see are called Talking Parents and Our Family Wizard. They are, I believe, both free telephone applications you can install on your phone, and it's a way to streamline the communication, right? And it helps to, number 1, keep track of what's going on, and number 2, document all of the communications, which could be important going forward. It's always difficult when you're like, well, I had text messages from years ago, but now I don't have them anymore. Having these sorts of communication platforms allows you to pull all that information up because it's never deleted. So those are 2 platforms that I always recommend, especially if there is a pretty high conflict situation, to help those parties have more effective communication, and also make sure that things are being documented appropriately. So again, when you are communicating, you want to consider, how are we going to handle the scheduled exchanges? Where are these exchanges going to happen? Who's driving the child? Sometimes parties have disputes about whether third parties can drive the child. Can stepmom or stepdad drive the child? Again, these are all things that need to be considered. And these logistics, they may sound minor, but again, they can create enormous friction when they're not addressed in the parenting plan. Component 4, so the decision-making responsibility. If you remember, that's what I referred to as, typically people think of it as legal custody. So decision-making is going to be who has the authority over major decisions, right? Education, healthcare, religion, their extracurricular activities. There are a couple of different ways decision-making is typically allocated. Joint decision-making means that both parents are going to have to make agreements on all of these major decisions, right? Sole decision-making means one parent has the final say. And then there are kind of in-between decision-making, such as tiebreaker authority, which is essentially sole decision-making, but it requires the parties to still, confer about the decision first. So decision-making needs to, of course, be specified in your parenting plan, especially for these major categories, and consider, what happens when the parents do disagree under a joint arrangement, right? If the parties are so high conflict that they just cannot ever reach an agreement, that is actually something that the court will consider in deciding whether sole decision-making is needed. And then the last component is dispute resolution. So what happens when you can't agree? We want to include a built-in process, right? So typically that's going to say, all right, if there's something that you don't agree on, communicate first, right? Required communication, typically written communication first. If you still can't agree, then potentially you go to mediation, right? You see if you can resolve this in mediation. And then if that is still unsuccessful, last resort is to return to court, right? So we want a well-drafted dispute resolution clause. It can save you tens of thousands of dollars and years of litigation. It's also a signal to the judge that both parties are committed to co-parenting, committed to trying to resolve these issues on their own before immediately just filing a motion in court, right? So the absence of any of these components is an invitation for future conflict. We want to build it right the very first time so that you don't have these issues in a few years down the road. All right, next slide, Steph. Okay. So topic number 3, scheduling models that work. So let's talk about, some of the actual schedules that we typically see in these sorts of parenting plans, what that might look like on your calendar. There's typically 4 main models that we see in parenting cases, and each of them have, their own strengths, and some work better in some situations than others. So there's no universally right answer. And as I said before, the facts of every case are very different. So what works for one family may not work for your family. The right answer really just depends on you, your children, your geography, your work schedule, your ability to co-parent, things like that. So let's walk through those 4 schedules, and I believe that is the next slide. Okay, so the first schedule is on the top left, and that's the week on, week off schedule. So the child would be spending full alternating weeks with each parent. Usually you see the exchange date be a Sunday. Sunday evening to Sunday evening is common, but of course you can adjust the transition day. I've seen midweek transitions as well. It just depends on, obviously the child's school schedule and your schedule, as well as your co-parent schedule. So the model is pretty simple. Kids know exactly where they're going to be. It works really well for older children, and for parents who live close to each other. The challenge, is that a full week is a long time for your kids to go without seeing you, and for you to go without seeing your kids. So a full week is a long time, without contact. And typically that's why I would say it's better for children who are a little bit older. With young children, especially babies, we want to make sure there's more consistent contact than going a whole week without seeing the child. And then we go to the top right, which is a 2-2-3 rotation, which is, again, much more time than the week on, week off, and it requires a lot more exchanges, right? So the child's with parent A, for example, on Monday, Tuesday, with parent B on Wednesday, Thursday, and then weekends, Friday through Sunday, are alternated, right? So you would essentially get every other weekend and then 2 days during the week. This means that your child's not going more than 3 days without seeing you. It's more frequent in transitions, as I mentioned. So, one of the factors that I take into consideration here is, are the parties having trouble with exchanges? And is there often conflict at exchanges? And if so, this may not be the best schedule. It can also kind of be disruptive for some kids. Switching so often can be difficult for some children. Some children don't have issues with it at all. But for young children, again, who need more consistent contact with both parents, this tends to work very well. The downside is the complexity. You really do need a detailed written schedule because the rotating weekend can be confusing. We want to know exactly the times. Is it going to be pickup from school? Is it going to be pickup at the receiving parent's house? All of those specifications are going to be needed so that there's no, again, vague or ambiguous terms here that can be interpreted in different ways. All right, then we have the bottom left, which is primary caregiver plus every other weekend. So this is where one parent is designated as the primary residential parent, where the child lives most of the time. The other parent has scheduled parenting time. And again, we don't really refer to that as visitation. We refer to that as still as parenting time. Typically, this is going to be an every other weekend plus maybe a midweek overnight, maybe even 2 midweek overnights. And this is kind of the traditional model. It still makes sense when the parties live a little bit farther apart. Or maybe when a child has special needs that require more consistency in their environment, or again, when your work schedules, make those equal joint parenting time models impractical. So the non-primary parent has not, again, lost their rights. They have full rights. They just have a little bit less parenting time. And then the bottom right is our hybrid custom schedules. Like I said, you can get very creative when doing a parenting plan. I honestly cannot think of 2 cases that have ever had the exact same terms in a parenting plan. So these hybrid and custom schedules, they're tailor-made arrangements. They don't fit, necessarily a standard model. They can incorporate shift work schedules, unique school arrangements, maybe summer schedules that are going to differ from your school year, which is something that we see frequently, especially if there are location issues where maybe a parent lives very far away. They can see the child much longer and frequently over summer breaks, right? Because the child's then not in school. So the key with custom schedules is, again, they need to be written in extraordinary detail. The more creative the schedule, the more careful you have to be about the language, being specific and not being ambiguous about any of those terms, right? So remember what I said earlier, whatever model you choose, you have to have at a minimum specific days and times, never is mutually agreed, never, the parties will confer on X, Y, and Z. It's got to be specific. You can always agree, of course, to modify it between the two of you, but at least you have that formal written court order that if you can't agree to a difference, this is what we fall back on. All right, next slide, please. All right, our common mistakes to avoid, our last topic here. So we've talked about the law, the components of a good plan, the scheduling options. Now, I want to just touch on things that I see parents do, both in terms of in drafting the parenting plan and in their behavior that could undermine the plan or damage their cases. So some of these mistakes people make knowingly because they're frustrated or scared. Some are mistakes people make, of course, without realizing they're even creating a problem, but either way, they could have consequences. So let's talk about both of those categories. And that would be on the next slide, please. Okay, so on the left here, we have plan drafting mistakes, right? So these are structural errors that kind of get baked into the plan itself. Vague language, and I know you're probably getting tired of me hearing that, but vague language is the biggest one. I can't tell you how many times I've seen has agreed in the parenting plan turn into litigation, right? So when your relationship with your co-parent is cooperative, vague language seems like a great idea, and then it deteriorates, and sometimes it does, and that language becomes a weapon. You have to write the specific terms. No holiday schedule, again, is extremely common omission. People think about Christmas or maybe Thanksgiving. They don't think about what we discussed earlier, you know, the fall, spring break, child's birthday, school in-service days, all of the holidays, right? Assign every one of those holidays. And if you don't assign a holiday, if you don't care about the Labor Day, Memorial Day, specify, you know, the typical plan is going to be in place on every other unnamed holiday, right? So then again, there's no ambiguity there. The missing communication terms. How do you handle a request to swap a parenting time day? What's the response timeline? Is there going to be a requirement that both parties need to respond within 24 to 48 hours? That's another big issue I've seen, is that the parenting plan doesn't specify a required response time. And, you know, parents sometimes will go days without responding to the other parent, right? We also want to talk about the platform that you're going to use. So like I mentioned, the Talking Parents or the Our Family Wizard. Are you just going to use texting? Are you going to use email? These things matter when the relationship becomes stress between the co-parents. Another common mistake is the no relocation clause. So this means, you know, what if one parent needs to move for work, for family, for a new relationship? Now, I will say Colorado does have very specific requirements about relocation. You cannot necessarily just take your kid out of the state, right? But even so, I do think it's better for your parenting plan to specifically address what's going to happen if that needs to happen, right? So sometimes this is often seen in cases where maybe the parties are military and expect frequent moves. That's another instance where we would want to have a very detailed relocation provision put in place. And on that same note, like the no modification process. So children grow, they become older, they are involved in different things, different extracurriculars, friends, etc. The circumstances change, right? So how is your plan going to get updated? If it needs to be, if you put it in place when the child is 2 and now they're 12, you may need to reconsider what the plan is. Building in a review process in the plan is important. So in the same thread of that, the dispute resolution clause, you know, we've said it before, we'll say it again. Build mediation in your plan before you default to court. It's cheaper, faster, better for your children. Okay, on the right, the behavioral mistakes. Okay, so these are things that parents do that damage their credibility with the court and potentially with their relationship with their children, okay? The first there, the withholding. Withholding parenting time is one of the most serious issues. Even if the other parent is a pain, even if you just cannot get along, even if they are maybe using derogatory, inappropriate language to you if they're behind on child support. If they violated the plan, you cannot withhold parenting time as a remedy. That is called self-help, and the courts take it very seriously. There's remedies you can take through the court to address these concerns. Specifically, you would file what we would call a motion to enforce parenting time to put this issue before the court. And specifically with that motion, if the court does find that the other parent is violating the plan, they can enforce sanctions against them. Typically, that means attorney's fees and costs, right? The second thing we want to be aware of is social media. I can't tell you how many times I have gotten an exhibit with a ridiculous post that my client made that does not look good, right? So assume everything you post during your divorce process, your allocation of parental responsibilities process, and after could be screenshotted and shown to a judge. So just have that in your mind. Would I be okay with a judge seeing this? And that goes even for if you have private accounts. You know, I've had those instances too, where the client's like, I don't even know how they got this. It's possible. So you just need to kind of have that frame of mind about what we're putting out there, because what you put out on the internet is forever. So the other real big behavioral mistake I see is using the child as a messenger, or asking them questions, or maybe to kind of report on the other parent. This is a term we call parentification, and courts are increasingly attuned to this. So, I mean, obviously it harms the child. It's going to harm your case. You don't want to put your kids in the middle of this situation that's often very tense and highly, high conflict situation as it is. We don't want to expose the children to that. And the court's going to be very sensitive to allegations about that. Failure to follow your own plan while expecting the other parent to follow theirs. Courts notice the asymmetry. Follow the plan. Just follow the plan. If your plan no longer fits and your child's needs have changed, if your schedules have changed, your work has changed, where you live has changed, circumstances have changed, the answer is a formal notification, not an informal draft, right? Not a talking parents message saying, hey, can we change the plan to X, Y, and Z permanently? You need to formally change it, right? Get that modification done properly so that you avoid future issues. All right, I think that ends topic 4.
Thank you, Taylor. I think that was a really good way to end it. And we can always, whatever agreements we came and that don't work anymore, you can always contact our office to see about modifications and the best way to go about those before you do anything on your own. It's definitely a good process to contact your lawyer. So Taylor, can you tell me just a little bit more about just parenting time and social media? I know you touched on it, and also, what happens when you're concerned about your co-parent, about X, Y, and Z. What can you do to get, the help properly? What do you recommend as a family law attorney?
Yeah, so I mean, the biggest thing, and I think we kind of touched on this when I discussed talking parents and our family wizard, is documentation. So if we have a parenting plan, or even if you don't have a parenting plan and you want to establish one, documenting anything and everything is going to be important. And what I mean by that is something that you might not think is relevant could be, right? So what I always ask my clients to provide me is text messages, emails, photos, anything that, especially if you have concerns about maybe the other parent's ability to safely or appropriately parent the child, we want to show the court why. It's otherwise it's just your word against the other person. So if your co-parent is sending you inappropriate messages, if your co-parent is putting the child in an unsafe situation, those things need to be documented. And even if you don't necessarily have court action going on right now, you may later. So, good rule of thumb is until your child is 18, to continue to document your concerns, to continue to document any issues with co-parenting, especially if you have joint decision making and it's really getting difficult to make joint decisions together. Maybe your co-parent is unreasonably not agreeing to something, you know, the doctor recommends something and the co-parent just won't agree to it. Those are all things you kind of want to, again, document, because if you do need to go and modify decision making, you've got to show the court why you're asking for that modification.
Great advice. Thank you. And we do have a question on the chat. Can you dig in more into the relocation clauses in Colorado?
Sure. So in Colorado, you cannot, once a dissolution of marriage proceeding is filed or an allocation of parental responsibilities proceeding is filed, there are automatic injunctions that go into place, meaning that neither of the parents can take the child out of the state of Colorado, right? So that protects us there, protects the child from being abducted to a different state. So right out of the gate, we have that. Additionally, you cannot take the child outside of the state as a relocation unless you have a court order or a written stipulation between the parties. I think it's important to still specify that in the relocation plan at minimum, but in situations where we do maybe have one or both parents that do anticipate relocating in the future, that's an area you can address that. You can address that in the parenting plan. You know, we have some military clients, and in San Diego, I had military clients, and you know, they anticipate moving. So putting something into place, if you can, about what's going to happen when I move, and do I have to get a court order, and am I, you know, do the parents agree that maybe mom is going to continue to be the primary caregiver once the child moves with mom due to this relocation, and what's the schedule going to be then? So it can get as intense and specific as almost doing two different parenting plans, which I've done before, which is when the parties are in the same community, this is what it's going to be. And when the parties are not in the same community due to a parent's military relocation or relocation for another reason, this is what the parenting time is going to be.
I love that. I like that idea, especially for our military service members, that you know that it could come, and it is coming. So that's a great way to approach it.
Right.
Thank you, Tia. Yes, we answered her question.
Thank you, Tia.
All right, Taylor. Well, thank you very much for joining us. That's the only question we had today. We appreciate you. Thank you for making time for us today.
No problem. Thank you. Hope everyone has a good rest of their day.
Bye-bye.
Bye.